Ladies and gentlemen, Excellencies, Justices, Chairman of the Supreme Court of Kazakhstan, Consul General, Ambassador, thank you very much indeed for coming to this, the second of our lecture series for 2015. And also for joining us for the official signing of a landmark document, a memorandum of guidance about enforcement between the DIFC courts and the United States District Court for the Southern District of New York, one of, if not the most important courts, financially speaking, in the United States of America. Welcome to those here today, welcome to those seeing us around the world on Thomson Reuters and WebEx technology, and welcome to those watching us on YouTube who weren't able to be here today but are watching it in repeat. The plan of action is that the document will be signed. Then Chief Justice Wang, I'll introduce Chief Justice Wang, who will say a few words about the document. I'll introduce Chief Justice Preska, who will say a few words about signing, and then we'll have the lecture. So may I invite Chief Justice Michael Wang and Chief Justice Loretta Preska of the United States District Court for the Southern District of New York to now sign the memorandum of guidance between our two courts. Please allow me to introduce Chief Justice Michael Wang, known to those in the room. But for those from around the world who will be watching this, Chief Justice is a graduate of Oxford University and a former law professor at the University of Sydney and the University of Singapore. He was a partner at Allen & Gledhill, the largest law firm in Singapore, and was head of its litigation and arbitration department for 10 years. He served as a judicial commissioner, the equivalent of a High Court judge, in the Supreme Court of Singapore, and since 2003 has practiced as an independent barrister and arbitrator. In 1997, he was appointed as one of the first 12 senior counsels of the Supreme Court of Singapore, and in 1999 he was elected a member of the American Law Institute, as well as a visiting professor of the National University of Singapore. He served as a commissioner of the United Nations Compensation Committee based in Geneva, and in 2005 was appointed the Deputy Chief Justice of the DIFC Courts, and in 2010, in June, he became the Chief Justice of the DIFC Courts. I'm delighted to announce that last year Chief Justice Wang was also appointed the head of the Dispute Resolution Authority of the DIFC last year, around the same time that he was conferred an honorary degree in Doctor of Laws by the University of Sydney. I invite Chief Justice Michael Wang to say a few words about the memorandum.
Good afternoon, ladies and gentlemen. It gives me great pleasure to be here today with my counterpart in the United States District Court for the Southern District of New York. Chief Judge Loretta Preska presides over the oldest and busiest district court in America. With jurisdiction over New York's finance centers, including Wall Street, she also presides over one of the most important commercial courts in the world. We have come together today to sign an agreement that will support the vibrant economic relationship that exists between the UAE and the USA, which has helped to create an estimated 200,000 jobs in each country. Much of the trade between the USA and UAE originates from or is routed via New York and Dubai. So there is an imperative for the court systems of both jurisdictions to work together to support the needs of business. Without a clear appreciation of enforcement and judicial procedures across borders, the investors would be wary of developing the trade and services networks that underpin long-term economic expansion. This memorandum of guidance sets out the procedures for the mutual enforcement of money judgments by our two courts, and it follows a line of other similar memoranda of guidance that we have entered into with the courts of England and Wales, Australia, Singapore, and Kenya. By providing additional contract certainty, it will be particularly important to the more than 1,000 American firms that have a presence in the Emirates and to UAE companies which are believed to have trade relations with every state in America. Following the signing of the memorandum, Chief Justice Preska will reinforce its significance during a keynote address which is entitled "The Elements of Commerce in the 21st Century, How Commercial Courts Enhance the City's Position as a Financial, Commercial, and Legal Hub." We greatly welcome this memorandum, which will bring further clarity to the relationship between our two courts and engender further confidence for those doing business between our two countries. Thank you.
Thank you. As Chief Justice Wang mentioned and detailed for us, we have such a strong bilateral trade relationship between the United States and the UAE, and particularly here in Dubai. You are the leaders of the commercial, financial, and legal world in this part of the world. It is of particular importance that our two courts understand the availability of recognition of foreign judgments and enforcement of foreign judgments. And because of this, it is our hope that the financial, legal, and commercial sectors on both our sides will benefit from additional certainty in planning their legal relations. It is a great honor to be here today and to reinforce the relationship between our two courts. It's a pleasure to be here.
It's now my distinct pleasure to introduce this evening's keynote speaker. During an exceptional career, Chief Judge Loretta Preska has consistently trailblazed the path for women in the legal profession, and I know that she is a true inspiration for my female colleagues currently rising through the ranks of the DIFC courts. Following graduation from Fordham University School of Law in New York, she spent 2 decades as a distinguished private practice attorney until her induction as a United States District Judge in the early 1990s. Appointed to the Southern District Bench in 1992, she became Chief Judge of America's oldest, busiest, and arguably most important district court in 2009. Chief Justice Preska has served as a member of the Committee on Federal State Jurisdiction of the Judicial Conference of the United States, as chair of the Bench Book Advisory Committee, the Board of Directors of the Federal Judicial Center, and currently serves on the New York Federal State Judicial Council. In a glittering career, she has been awarded the Medal of Achievement from the Fordham Law Alumni Association, the Edward J. Weinfield Award from the New York County Lawyers Association Federal Courts Committee for Excellence in the Administration of Justice, the Charles Carroll Award from the Catholic Lawyers Guild, the Stanley H. Fold Award for Outstanding Contributions to the Development of Commercial Law and Jurisprudence, the President's Special Award from the New York Women's Bar Association, the Barbara Jordan Outstanding Public Service Award from Phi Alpha Delta Law Fraternity International, the Women in Business Law Lifetime Achievement Award, and the Boris Kostelanets President's Medal from the New York County Lawyers Association in 2014. So we are honored that someone of Chief Justice Preska's stature can be with us this evening to share her thoughts on how commercial courts can enhance the city's position as a financial, commercial, and legal hub. Chief Justice Preska.
Thank you, Chief Justice Wang. Salam alaikum. Chief Justice, Justices of the DIFC courts, Registrar Beer, honored ladies and gentlemen. As you've heard, I am the Chief Judge of the Federal Court in the Southern District of New York. Our court was the first federal court to sit under our country's then new Constitution on the first Tuesday of November, 1789. Doing the math, you will learn that we've celebrated this year the 225th anniversary of that first sitting. The first session of the court was held in the old Exchange Building in Lower Manhattan. did prepare a few slides, just so it would be a little more interesting to you, and we're about to get them ready to go. Okay. So the first session of court was held in the old Exchange Building in Lower Manhattan, and it was presided over by Judge James Duane, a former mayor of the city of New York. Not that that first sitting in any way reflected our court's docket of today. Indeed, the entire news report of that first sitting read, on Tuesday, the federal court for the District of New York opened in the Exchange. His Honor, Judge Duane presiding. No business being before the court, the same was immediately adjourned. But New York had already had over 165 years of history before Judge Duane's opening of our court. Although Manhattan had been purchased by its previous tribal inhabitants in 1626, it was first settled by the Dutch in 1624, and Henry Hudson sailed from Holland into New York's Upper Bay way back in 1609. Handsome man, don't you think? Russell Shorto, the author of Island at the Center of the World, has pointed out at that time, Holland was the most forward-thinking country on the earth, and it was populated by merchants. That is the DNA of New York. Now, some 400 years later, Dubai and the Dubai International Financial Center courts in particular seem to me to have similar DNA. Dubai is the most forward-thinking hub of this region, and the DIFC is a major center of commerce and finance. Also, as former mayor of New York Michael Bloomberg said recently during a conference here in Dubai, just like Dubai, where people from over 200 countries coexist with each other, New York is also home to a large population not born in the United States. Thus, by our DNA, Dubai and New York are related. So with this shared background in mind, in preparing to visit with you, I thought about the essential elements for commerce in the 21st century. Of course, I didn't think of them as an economist, but only as a judge from New York. The first element that came to mind as required for commerce in this new century is an educated population. In 1754, by royal charter of King George II, King's College was established in New York in a building adjoining Trinity Church in Lower Manhattan. It was the first college opened in New York State and eventually became Columbia University, now located in Upper Manhattan. Here in Dubai, I read Sheikh Mohammed bin Rashid Al Maktoum's book, Flashes of Thought. And he said there that a mere 40 years ago, there were only 74 public and private schools in the entirety of the UAE. Today, there are over 1,200 schools, and the UAE has become renowned for the education of women. According to the Knowledge and Human Development Authority, there are almost 60 higher education institutions in Dubai alone, educating more than 52,000 college students from over 140 countries. So in my view, the element of an educated population is satisfied in both of our locales. The second element necessary for commerce in the 21st century is a safe investment environment. In New York, the formal buying and selling of stocks is said to have begun on May 17, 1792, outside of 68 Wall Street, under a buttonwood tree. There, 24 stockbrokers signed what came to be known as the Buttonwood Agreement, specifying how they would sell stocks to the public. There were only 5 securities traded at the outset, the first one being the Bank of New York. The Buttonwood Agreement was the forerunner to the New York Stock Exchange, the world's largest stock exchange measured by the market capitalization of listed companies. It stood at $16.6 trillion this past February. Here in Dubai, Sheikh Mohammed has pointed out that, quote, the UAE has for years been known as a pillar of stability in the Middle East. Our status as a safe destination for investment is linked to our role as a regional business hub and economic gateway, close quote. He also said, the UAE, quote, embraces people from 200 nations, all working, investing, and giving the best they have to offer, quote. The bilateral trade relationship between the UAE and the United States is very strong and is yet another reason to encourage cooperation between the US and the UAE courts. The DIFC is a particularly attractive investment environment with its very favorable tax regime. And, like New York, Dubai and the other GCC countries have the most important ingredient of any capital market, a giant pool of liquidity. So again, in my view, the element of a safe investment environment is met in both of our locales. Now, of course, a safe investment environment leads to business transactions, large and small. In the 1780s, for example, John Jacob Astor began as a humble fur trader in a small shop in New York City. By 1830, Astor's empire extended into the Great Lakes, into Canada, and all the way to the Pacific Ocean. No small feat in those days. At that time, sensing that the demand for fur was decreasing, Astor decided to exit the industry that had made him a rich man and invested his fortune back in New York City, buying up a vast amount of real estate and becoming a famed patron of the arts. A more recent tale of humble beginnings involves a man you might have heard of. His name is Steve Jobs, who famously tinkered in his parents' basement on the way to founding Apple, the world's most valuable company. Here, Sheikh Mohammed has announced a goal of, quote, improving the entrepreneurial sector by supporting small and medium-sized enterprises and instilling an entrepreneurial culture within our schools and universities. He says, we want to build a generation of hardworking and creative young entrepreneurs with great courage and ambition, as well as a sense of responsibility. So, conditions in both our locales are ripe to encourage the next Steve Jobs, the next entrepreneur who is going to invent some great tech product. Commercial development of the 21st century, however, requires infrastructure to support the businesses. To that end, we see grand public projects in both our locales. In New York, we're rebuilding a major transportation hub and office complex in Lower Manhattan in the World Trade Center area. At approximately 800,000 square feet, the hub, designed by internationally acclaimed architect Santiago Calatrava, will serve over 200,000 daily commuters, as well as millions of visitors from around the world annually. It'll be the third largest transportation center in New York City, rivaling the famous Grand Central Station in size. The hub's concourse will conveniently connect visitors to 11 different subway lines, the Port Authority Trans-Hudson Rail System, the Battery Park City Terminal, Ferry Terminal, the World Trade Center site, World Trade Center Towers 1, 2, 3, and 4, the World Financial Center, and the Winter Garden. It will represent the largest underground integrated system of tunnels in the city of New York. Here in Dubai, recent heavy investment in transport, telecommunications, energy, and industrial infrastructure has been truly remarkable. Sheikh Mohammed notes that, quote, in recent years, the UAE has been able to develop its infrastructure up to truly global standards. Indeed, the most recent Global Competitiveness Report ranked the UAE 6th worldwide on the Infrastructure Quality Index. I suggest to you, one need look no further than Burj Khalifa to see proof of his words. 4,000 years ago, the tallest buildings in the world were the pyramids in Egypt. Today, it is Burj Khalifa. Now, all of these economic and commercial factors tend to pull investment to a locale. An educated populace, safe investment environment, business transactions, and infrastructure upgrades make an investment locale attractive to investors. Professor Sir Geoffrey Jowl, director of the Bingham Center for the Rule of Law in London, has noted that investment decisions are also disincentivized or pushed away from a locale by a different but no less important factor, and that is a fair dispute resolution system. Professor Jowl notes various attributes required for such a system. The first is legality, that is, a system of law not arbitrarily applied and where feasible enforced. In other words, no person is above the law. The second attribute he notes in such a system is predictability. Lawyers, like many of you here in the room, should be able to advise their clients of the likely outcome of a commercial dispute with a high degree of predictability. The third element that the professor notes is the equal application of the law to all, rich and poor, powerful and weak. He notes that the corruption we see in so many places around the world that prefers those who can purchase justice over those who cannot is antithetical to this requirement. And finally, he notes the requirement of an independent judiciary and the independence of the other participants in the legal system, the prosecutors and the lawyers who represent their clients zealously without fear or favor. The Bingham Center's research shows that these rule of law considerations routinely influence investments away from locales that do not have the rule of law. A fair dispute resolution system is thus demonstrated to be an important element in commerce in the 21st century. This is, I suggest, a point of immense importance to the people in this room. For the business people who work so hard on the economic and commercial factors to pull an investment to a locale, it's important to recognize that the absence of a fair dispute resolution system will push those investments away. Thus, it makes good sense for business people to support an independent judiciary guided by the rule of law. To the lawyers in this room, it is obvious that an increase in business activity brings an increase in legal work. So of course it's in your best business interest to support the rule of law. And to the judges in this room, this finding means that it is in a locale's national economic interest that we embrace the rule of law, that we render decisions predictably, without fear or favor, according to fair procedures. So how are our two locales doing on this element of 21st century commerce? Well, you've already heard that in 1789, the federal court sitting in New York was not exactly overwhelmed with business at its first sitting. Later on, though, our court received a lot of admiralty business, including the prize cases. Prize cases originated from the wars between France and Britain in the 1790s. If a vessel were captured running a blockade, for example, the captors asked the court to rule that the vessel had been rightfully captured, and most importantly, that the captors were entitled to keep the vessel and her cargo. Pretty nice, right? In 1792, a French frigate captured the Catherine, a British brigantine off the coast of New Jersey, and sent her to our port in the port of New York as a prize. Judge Duane, however, ruled that the seizure took place in American neutral waters, and therefore it was not a fair prize. So the result was that the owners, citizens of Britain, our then very recent enemy, had the right to claim their property back from the captors, citizens of France, our then very recent ally. In 1913, Judge George Chandler Holt of our court presided over a petition by the owners of the Titanic. The petition wished to limit the owner's liability for the tragedy, of course. The main question decided by Judge Holt was whether the law of the United States or the law of Great Britain applied. If the law of the United States had been applicable, the owner would have been able to limit his liability. If the law of Great Britain applied, however, he faced fairly certain financial ruin, as you can imagine. Despite that financial ruin facing the owner, Judge Holt found that the owner could not take advantage of the United States law, especially considering the uncontradicted facts that, quote, the Titanic was a British ship owned by a British company which foundered in mid-ocean from collision with an iceberg. I must note for a moment, though, that the Supreme Court later disagreed with Judge Holt. But for our purposes, it's important to note that even in these older cases, judges rendered decisions that were perceived to be against powerful or popular interests. Since then, the number of high-profile commercial cases in our court has increased immensely, and our judges have heard some of the most complex and sometimes headline-grabbing cases in the world. For example, in 1941, the United States Department of Justice sued the Aluminum Company of America, Alcoa, alleging various antitrust violations. The case went on for years and defined the contours of antitrust law in the United States. Some of those, few of you in this room who are my age, will remember that in 1984, the Union Carbide plant in Bhopal, India, accidentally released toxic chemicals into the atmosphere, killing and injuring scores of people. The thousands of personal injury cases and scores of securities law cases that arose out of that disaster were all litigated in our court as a multi-district litigation. That is, a case where cases from all around the country on a common topic are collected in one court for efficient resolution. Today, our court has more multi-district litigation than any court in the country, including litigations arising out of the collapse of WorldCom, the collapse of Lehman Brothers, the Bernard Madoff Ponzi scheme, cases involving the drugs Fosamax and Ritalin, and cases recently arising out of the General Motors ignition defects. In the 21st century, of course, as we've heard today, commercial dispute resolution has to operate on two tracks, one judicial and one an alternate dispute resolution track, often mediation or arbitration. In New York, Judith Kaye, the former chief judge of the New York Court of Appeals, which is the highest court in New York State, has started the New York International Arbitration Center. It's in a beautiful space, which is funded by 37 law firms and provides space and facilities for the arbitration of international disputes. It will celebrate its second birthday this June, and it's hosted numbers of hearings, including commercial arbitrations between private parties involving oil and gas, construction, intellectual property, and at least one major arbitration dispute arising out of a bilateral international treaty where investors could invoke arbitration in a dispute with governments and governmental entities. You here in the Dubai International Financial Center have created a world-class dispute resolution center. Recognizing the need for dispute resolution options, as we heard earlier from Mark, Sheikh Mohammed approved Law Number 7 last year to create the Dispute Resolution Authority within the DIFC. This authority, as you know, is a consolidation of the litigation and arbitration functions and has been established in accordance with best practices worldwide. This development, which took place under the leadership of Chief Justice Wang, is in line with UAE's Vision 2021, which, quote, calls for the provision of an effective and sophisticated disputes settlement so that the UAE becomes the first destination globally to attract business and finance. Thus, the UAE Vision 2021 itself recognizes that a fair dispute resolution system is essential to commercial development. For example, although most countries in the world have moved past trial by ambush, it's much less common to find dispute resolution entities that have pulled away from the commerce-inhibiting effects of corruption. As you can imagine, every year in New York, just like Chief Justice Wang, we meet and host all sorts of visiting judges from around the world. With the exception of a few countries, including the British Commonwealth countries, a common reaction is disbelief that we have an independent judiciary. Sometimes those judges ask who we call to find out how we're supposed to rule, and some of them express great surprise that there's not an office for the political officer in the courthouse. In 18th century England, King George III exerted very strong control over his judges. If they ruled against his wishes, he reduced their pay or even threw them out of office. To counter that, the framers of our Constitution provided that federal judges are appointed for life, and their compensation may not be diminished during their lifetimes, assuming good behavior, of course. So far, I have not had any trouble with the good behavior part. I was nominated by President George H.W. Bush in 1992 and may serve for life. You have created a superb judiciary here in the DIFC courts, as exemplified by Chief Justice Wang. His broad expertise in international affairs, litigation, and arbitration has already been detailed for you by Mark, but I must say it is truly outstanding. And he is not alone among the judges of the court. Deputy Chief Justice Sir John Murray Chadwick was standing counsel to the UK Development of Trade and Industry from 74 until 80. Justice David Steele, a judge of the Commercial Court and an Admiralty judge, served as judge in charge of the Commercial Court in the High Court of London, and was presiding judge of the Western Circuit in the early 2000s. He was appointed as Queen's Counsel and then served as a member on the panel of Lloyd's salvage arbitrators. His Excellency, Judge Omar Al-Muhari, before serving as a judge in the DIFC courts, was a prosecutor for the Dubai Public Prosecution and a management associate for the Dubai Financial Services Authority, working, quote, to provide the DFSA with a working knowledge of the UAE laws and its future correlation with the DIFC laws. He was also a member of the committee that established the DIFC courts. These examples only begin to scratch the surface of the vast knowledge and experience in this room and in these courts. These jurists' background in common law courts bring with them a tradition of independence. You have further assured the independence of DIFC judges by providing, quote, the judges appointed under Article 3.4 of the Judicial Authority Law shall be appointed for a specified period not exceeding 3 years and may be reappointed, providing that that period does not extend beyond the day when the judge turns 75. Further assuring the judge's independence, judges may only be removed from office by a decree issued by the ruler for reasons of inability, incapacity, or misbehavior that is found to have been taken place by an independent inquiry established by the ruler and whose findings have been published. More support for the independence of this judiciary. In addition, observations about due process. The DIFC courts have adopted rules for service and notice that are consistent with universal notions of due process. For example, Part 9 of the court rules lays out a detailed account of proper service and checks and balances on both the parties and the courts. And I note that the rules expressly provide for service outside of the DIFC, providing that a party must comply with the rules of service and notice of a foreign jurisdiction. Again, this is another example of the high standards which the DIFC courts uphold while respecting international parties and the rule of law in other jurisdictions. The overriding objectives of the court rules, as mentioned in Part 1, strike me as worth repeating, since these goals are shared by our courts and all courts looking to observe the rule of law. The objectives are fivefold: ensuring that parties are on an equal footing, saving expense, dealing with cases in a proportionate way, ensuring that cases are dealt with expeditiously and fairly, and allotting each case its appropriate share of the court's resources. And in my experience as the chief judge, where I'm responsible both for managing the court and for deciding cases, the provision and communication of balanced, clear, and easy to understand procedure is essential. Clear communication of procedure, of course, is what brings us here today. One other note. I note that in 2008, the DIFC courts added its first woman judge, as well as 2 Emirati judges. Our court did not have a female judge until 1966, when the Honorable Constance Baker Motley was appointed. She was an African-American woman who had worked on cases desegregating education in the United States with future Supreme Court Justice Thurgood Marshall, and she had served as president of the Borough of Manhattan. Presently, of the 48 district judges on our bench, 16 are female and 11 are racial or ethnic minorities. Our court's judges come from all parts of the practice. Some notable examples in the commercial realm are Judge Duffy, who was regional administrator of the Securities and Exchange Commission, Judge Caproni, who was general counsel and senior vice president of the New York State Urban Development Corporation, Judge Etkin, who was senior vice president, associate general counsel, and head of litigation at Cablevisions Corporation, and Judge Berman, who was general counsel to what was then Warner Cable Corporation, now Time Warner Inc. Several of our judges were sophisticated commercial litigators with major law firms, and others served in government, including as White House counsel and many as federal prosecutors. Although I was a chemistry major as an undergraduate, I did have 20 years of commercial litigation experience before going on the bench, working in contracts, antitrust, securities, defamation, and the like. Based on the above, I think we can agree that our 2 jurisdictions have put in place fair dispute resolution systems. But I suggest to you that in this 21st century, more is required to encourage commerce. Commerce in the 21st century is different from what it was in the 19th century. At that time, for example, the opening of the Erie Canal which allowed goods to be brought to New York by water from the middle of the United States. That opening was a technological breakthrough and brought with it increased commerce to New York and to the Midwest. Today, however, commerce is global. Over the last 10 years, capital investments by the UAE in New York have been strong. Such investments included projects in a variety of sectors: sports, real estate, financial, and technology. For example, Mubadala-owned chip company, Global Foundries, is focusing the majority of its $9 to $10 billion investment in Saratoga County in upstate New York. The DIFC currently hosts regulated firms from across the globe, including 34% from Europe, 29% from the Middle East, 15% from North America, 12% from Asia, and 10% from the rest of the world. It's little wonder that DHL, the worldwide logistics company, ranked the UAE number 12 in its annual Global Connectedness Index, a measure of globalization. And I will note for you that that's only one place behind Hong Kong. Because commerce now is so international, it's more than necessary for judgments recorded in one country to be easily recognized in another. After all, if the original case was tried fairly, there should be no need to expend the time and the resources to retry it in a new jurisdiction. And so we recognize the monumental step that our two jurisdictions have taken here today. Our two vibrant commercial centers have taken this huge leap forward into the 21st century global economy by providing guidance for business people and lawyers about our respective countries' abilities to recognize and enforce judgments rendered in the other country. Why is this so important, you might add? Well, recognition and enforcement of judgments between our two countries is important first, as I said, because of the highly international character of commerce today. Dubai is a broadly diversified economy based on international trade, banking, tourism, real estate, and manufacturing. It counts as its trading partners major banks and financial institutions, manufacturers, numerous Fortune 500 companies. The DIFC clientele includes 21 of the world's 25 largest banks, 11 of the world's top money managers, 7 of the 10 largest insurance companies, and for my lawyer friends here, 9 of the top global law firms. Like the DIFC, New York is home to numerous major U.S. and international corporations and banking institutions, including 54 Fortune 500 companies, 6 major stock exchanges, including the world's 2 largest exchanges, the New York Stock Exchange and NASDAQ, as well as the American Stock Exchange, International Securities Exchange, New York Board of Trade, and the New York Mercantile Exchange. So the first reason that our memorandum of today is important, because the companies are present in our respective locales, because it is a natural consequence of business. The commercial disputes are here also. And so our respective dispute resolution entities are very busy. Perhaps because New York has a long history of international commerce, it is particularly hospitable to the recognition and enforcement of foreign judgments. In recognition proceedings, there's a presumption of validity. A final conclusive judgment ordered by an impartial tribunal having proper jurisdiction and applying due process will likely be recognized without the need to re-adjudicate the case in New York. There are several exceptions, the major one being fraud or repugnancy to public policy. Proceedings in New York may be brought in 3 ways. by an action on the judgment, a motion for summary judgment in lieu of a complaint, or if there's a pending action, by adding a counterclaim, cross-claim, or affirmative defense. These and the other provisions are codified in New York law, and the law does recognize the presumption of validity, balanced against public policy. You say, well, what might that be? Public policy exceptions are very rare. For example, in 2008, the New York legislature added a provision for the extra protection of free speech. The provision bars recognition of a foreign defamation judgment unless the New York court determines that the defamation law applied in the foreign court is at least as protective of free speech as the New York and US constitutions. But in sum, recognition and enforcement proceedings in New York are summary. Also, like the DIFC courts, New York courts go out of their way to respect the voluntary choice of parties as to a choice of forms. And thus, I'll also note that New York is particularly hospitable to the recognition of international arbitration awards. The guidance between our two jurisdictions, however, is important for a second reason. Because the companies are present in our jurisdiction, so are the assets. What good is a judgment if you can't enforce it? New York law gives judgment creditors broad rights of global discovery to locate assets, and it allows for the possibility of pre-judgment attachments and injunction against the transfer of assets located in New York that can be used to satisfy the foreign judgment or arbitral award. In sum, I am here to assure you that I and my colleagues in the New York federal and state courts are committed to moving the processes of recognition and enforcement of foreign judgments along efficiently and smoothly. We hope to enhance New York's position as a financial, commercial, and legal hub. I invite all of you to visit our courts and to come in and see what kinds of cases are being litigated. In conclusion, I will note that in 1829, an association of inventors called the American Institute hosted the first World's Fair in New York. The fair was held in New York City and contained the latest advancements in agriculture, commerce, manufacturing, and the arts. It was a modest beginning, but it did recognize the importance to New York of attracting international business. In 2020, Dubai will host the World Expo, a first for the Middle East, North Africa, and South Asia. The theme, Connecting Minds, Creating the Future, embraces the globalized world of commerce and development. The mention of minds reflects the importance of building knowledge and partnerships, something that brings us together here today. The signing of this memorandum between our two jurisdictions reflects the mutual respect and shared pursuit of excellence in the field of dispute resolution in the realm of international commerce. And so I'm here to celebrate with you the signing of this memorandum. Thank you for giving me the opportunity to speak, and I must note I owe special thanks to Chief Justice Wang, to Registrar Beer and his entire team, including Natasha Barici, Hajar Amas, and Cheryl Hernandez, for hosting me and making my visit so pleasant. It's an honor to be with you all, ladies and gentlemen. The Chief Justice has noted and given me a little time for questions and answers if any of you would like to do that. Do we have a question? Sir.
Good evening and thank you. Good evening and thank you very much for making the effort to come to Dubai. Raise my hand, Clyde and Co. It was a very engaging speech and we loved it. I'd just like to ask you about some of the issues that may or may not appear in the future, or if you've had any experience in relation to turnover orders, and what your thoughts and opinions would be on turnovers from UAE or specifically DIFC awards and judgments. Thank you.
I don't think I can give you that detailed a response.
Okay, thank you very much.
You're very kind.
Thank you, but that's the only question. Thank you.
Thank you, sir.
I have a question. The Memorandum of Guidance sets out the principles on which, among other things, DIFC court judgments will be enforced in the USA. Right, in New York. My question is whether or not the principles set out for New York would be broadly the same as the principles that other states in the USA would apply if a DIFC court's judgment landed in their state.
In general, yes. But each state may, of course, adopt its own laws and rules, and every once in a while you'll find a little kink. For example, there was a state, and I don't know if it still is the case, that in addition to the requirements that I mentioned, you know, independent tribunal, proper jurisdiction, due process, etc., also required reciprocity of recognition. But in general, most states will have similar types of requirements. Because we are common law states, but from Louisiana, of course. And the recognition of foreign judgments is according to the common law doctrine of comity, that is, having respect for the judgments of other countries. It was a complete pleasure to be here with you. I look forward to chatting with you afterward. Thank you for welcoming me.
Wonderful. Well, huge thanks to Chief Judge Preska and to Chief Justice Wang for what I hope you found to be a very interesting and excellent presentation. I'd very much like to also recognise Natasha and Kat. Kat is over here, Natasha here, who worked so hard in pulling this document together over the last, I would say, 8 to 9 months. So a huge amount of effort on their part. To Rob Waller, Consul General for the United States of America, and to Mike Gunnison from the Justice Department in the US, who have managed to make sure that we are here today with the full support of those people that need to support us from the United States side. To Haja, to Haley, and to Nilofer from the DIFC courts, Haja's over there, for all their efforts. To Sunil for capturing our events, and to Thomson Reuters for this technology which allows us to be beamed all around the world to allow lawyers to watch us live or on YouTube. And lastly, but by no means least, to all of you for coming along this evening to hear about the wonderful memorandum between our courts. For those who crave more, please sign up to our annual Legal Gala dinner, which is taking place in October, and Haja has the details. Until we meet the next time, thank you very much and good evening.